Hey, what's up, Internet? Welcome to Widener Law. Today, I want to talk about tribute bands and some of the legal issues that they might bring into play. If you're not familiar with tribute bands, whereas a cover band is a band that plays music by a bunch of different groups or artists, usually within a particular genre, or maybe from across a few genres of music, a tribute band is a band that typically dedicates themselves to playing the music of one particular group or artist. Most of the time, they go a lot farther than just playing that artist's music, and they might dress up like the group that they're paying tribute to, or take on the persona of the original band when they're on stage. I actually saw a Led Zeppelin tribute band one time that essentially recreated the entirety of The Song Remains the Same, which was a live concert that Led Zeppelin filmed and released. It was a concert that they did back in the 70s. And this band was playing the live versions of all the songs, which was cool. They were playing them in the order that they were played in the original film, but they were also doing the exact same dialogue from the original film in their live tribute show. I thought it was just a little bit silly, but there are all kinds of tribute bands out there for real, from Led Zeppelin and Pink Floyd tributes to Elton John and ABBA tributes. There are Dave Matthews Band tributes, Pearl Jam tributes, Metallica tributes. They're literally just all over the place, it seems like. And a lot of times there will be a whole bunch of tributes to like a really big name act. But since tribute bands are all over the place, I think a lot of people assume that tribute bands must be legal, and it's not really that simple, because there are a whole lot of intellectual property rights at play when we start thinking about the things that tribute bands are doing. There are copyright considerations, and trademark law comes into play for sure. There's actually also a less commonly talked about area of intellectual property law that comes into play here. It's called the right of publicity. And a lot of these laws actually have some pretty strict penalties. I do think, by the way, that there is an avenue for tribute bands to do what they do legally, but I think it would be extremely difficult and kind of unlikely that they would be able to do it. And I would bet that most of them probably aren't doing it that way. So let's break down some of these intellectual property laws and see how they might apply to tribute bands, starting with copyright law. But first, this is unequivocally not legal advice. If you are in a tribute band or you're thinking about starting a tribute band, I absolutely recommend, personally speaking, with an attorney who knows about this kind of stuff, because I do think that there is quite a bit of risk involved, for sure. So, copyright law in the United States is all federal law, and it's laid out in Title 17 of the United States Code. Essentially, copyrights protect the authors of creative works. Those works could be books, movies, paintings, photographs, sound recordings, or a whole bunch of different types of things. A copyright protects the authors of those works by giving them multiple rights in that work. So a copyright isn't just one right. It is a list of things that the author of that work gets to do, and they also get to stop other people from doing those things with that work that they've created. Some of the rights that a copyright gives a creator are the right to make copies of the work, the right to distribute copies of the work, the right to create future works that are based off of that original work, and the right to publicly perform or display the work. There are a couple other ones. But if you're interested in learning more about copyright law, the U.S. Copyright Office actually has a series of PDF circulars on their website that you might find helpful, and I'll link to that, to the Copyright Office website in the description. As always, I recommend speaking with an attorney if you have any specific legal questions, copyright or otherwise. But when it comes to copyright law and tribute bands, or even just cover bands, we're mainly dealing with the right of public performance that a copyright provides the artist who originally wrote the music. The way that the music industry in particular works is that PROs, or performing rights organizations, collect royalties on behalf of songwriters who have registered their songs with the PRO. In the United States, the two main PROs are ASCAP, which is the American Society of Composers, Authors, and Publishers, and BMI, which is Broadcast Music Incorporated. The short version of how this works is that songwriters and music publishers register their music with one of these two companies. Music venues pay these companies an annual fee, and then these companies use those fees to send royalty payments out to the artists and publishers based on how many times their songs have been played. So, as long as the venues these bands are publicly performing the copyrighted music in are paying those annual license fees and doing everything else that they need to do, those public performances likely aren't infringing upon the public performance right of any of the copyright owners. But when it comes to recording the music or the performances, we move away from that right of public performance and into some of the other rights that copyright provides, which aren't covered in the licenses provided by ASCAP or BMI. It is actually possible to legally make an audio recording of someone else's musical composition even without their permission. It involves a mechanical license, which is a compulsory license, meaning that as long as all of the necessary steps are taken and requirements are met, the copyright holder can't actually prohibit anyone from doing this. I definitely don't recommend trying to do this without speaking to an attorney, but if you're looking for more information, Circular 73B from the U.S. Copyright Office is where I would begin. And I can link to that below too. When it comes to making a video that has someone else's copyrighted music in it, whether it's the original version that the copyright owner recorded or a version that a tribute band or a cover band recorded, that requires what's called a synchronization license. This is not a compulsory license, and at least as far as I know, there isn't a way to legally do this without the express permission of the copyright owner. So that means that if a tribute band or a cover band is posting videos of themselves playing other people's songs without the express written permission of the copyright owner, they are probably infringing. And as an FYI, according to Title 17 of the U.S. Code, Section 504C2, if a copyright owner proves and the court finds that copyright infringement was committed willfully, the court can increase the award of statutory damages to a sum of up to like $150,000. And that's per copyrighted work, so per song, basically. Moving into trademark law. Looking at the trademark issues around tribute bands, this is where most of the legal disputes that I've read about are actually taking place. When we talk about a band's trademark, you might think of Eddie Van Halen's guitar tone or Steve Harris's bass gallop that is, the underpinning of so much Iron Maiden's music. While it is possible to trademark sounds, that kind of thing isn't really what trademark law is designed to protect. What we're really talking about is are band names and logos. So a trademark is a name or a logo or a symbol that acts as a source identifier for whatever particular goods or service a business is selling. In this context, the goods and services are going to be the music, the live performances, and whatever merchandise a band is selling. And the source of those goods and services are going to be the artist or group that the mark identifies. So think the Rolling Stones Lips logo, or the Aerosmith Wings logos, or Metallica and the Metallica font. And each of those bands' names is going to be a trademark also. Believe it or not, most big name rock bands like this have a team of rock star attorneys that are charged with protecting the band's intellectual property rights. The Federal Trademark Database contains a whole bunch of registered trademarks on various lines of goods and services that are owned by big name rock bands like that, and pop bands and whatever. Now obviously tribute bands want to tie themselves to the bands that they're paying tribute to. That's kind of the point. The trick from the perspective of the tribute band is going to be doing that without infringing against any of the original band's trademarks. Like copyrights, trademark law is mainly federal law. The Lanham Act, which governs U.S. trademark law, is found in Title 15 of the U.S. Code. And contrary to the instinct of most of the musicians that I talk about this stuff with, barely changing the name of a hugely famous band does not mean that you aren't infringing against their trademarks. While there are a few different types of trademark infringement, Probably the most common type is when a mark creates a likelihood of confusion with a different mark that was already being used. Ironically, there doesn't actually have to be proof of confusion to find this. Both the Federal Circuit Court of Appeals, which has nationwide jurisdiction in trademark matters, and the U.S. Patent and Trademark Office, where trademarks can be registered with the federal government, use a 13-factor test that the Federal Circuit laid out in the DuPont case. After cautioning that there is no litmus rule which can provide a ready guide to all cases, the court laid out a bunch of factors that courts, the USPTO, trademark attorneys, and business owners seeking to create new and protectable marks should all consider. Without doing a deep dive into all 13 DuPont factors, suffice it to say that the two most important factors are generally going to be the similarity of the marks, taking into account their appearance, the sound, the connotation, and commercial impression, and the similarity of the goods or services on which the marks are used. Also note that some courts will explicitly consider the perceived intent of the user of the secondary mark. So were they purposefully trying to gain a commercial benefit from the value of the prior mark and thereby essentially rip off the owner of the prior mark? So two trademarks absolutely do not have to be identical to each other for one mark to be infringing upon the other mark. I think that's a pretty broad misconception. Generally speaking, there does have to be some level of similarity between the marks, but that's a line courts will sometimes draw pretty broadly. Based on these factors, if a tribute band is using a name or logo that's very obviously a play on the name or the logo of the band that they're paying tribute to, that's not going to play very well in their favor if there ever is a dispute. A lot of tribute bands will either use an exact song title or some clever play off of the song title or a lyric of the main band. That's arguably a safer bet than playing off of the main band's actual name, because song titles and lyrics, generally speaking, aren't going to be protected under trademark law. That's not to say they aren't protected under other laws, but that said, it's by absolutely no means a safe bet for a tribute band to play off of a title or a lyric, because there are all of these other factors involved in an infringement analysis. If a tribute band is doing what tribute bands do, the goods and services they're using, their name and logos to promote, like live musical performances, maybe some recorded music, and any merchandise they might be selling, these are going to be the exact same types of goods and services that the band that they're paying tribute to is famous for selling. That's also going to really hurt if there's ever a trademark dispute between the original band and the tribute band. So the short version is, I think there's a pretty strong likelihood that a lot of tribute bands out there are very arguably infringing against the trademarks of the original bands. Another area of intellectual property law that could come into play here is the right of publicity. While it might not have become part of the public lexicon the way that copyrights and trademarks have, it's absolutely a legitimate area of intellectual property law, and I think it definitely has a place in any discussion about the legality of tribute bans. Unlike copyright and trademark law, there isn't really a right of publicity at the federal level, and it's mainly handled by state laws. Some states have actually passed right of publicity statutes, and some states have only recognized a right of publicity through common law, which are laws that have been established by judicial precedent in the courts. Other states actually have both statutory and common law right of publicity protection, and according to the American Bar Association, at least 35 of the 50 U.S. states recognize a right of publicity in some form or another. Because it's pretty much all state law, and because all states do things a little bit differently, getting into the ins and outs of every right of publicity law across the country would take way longer than we have here. Generally speaking, though, the right of publicity protects a person's name, image, voice, signature, and likeness. Sometimes the person has to be a celebrity, sometimes they don't. Sometimes the right of publicity ends once the person dies. Sometimes it survives the person's death, and a claim can be brought by their estate, for example. There are also a few different tests used to determine whether a person's right of publicity has been infringed, but according to the American Bar Association, the more modern approach basically requires that a defendant, so this would be the tribute band, has used some aspect of the plaintiff's identity or persona in such a way that the plaintiff is identifiable from the defendant's use, and the defendant's use is likely to cause damage to the commercial value of that persona. So generally speaking, it looks like the right of publicity usually applies to individuals instead of groups or acts, but I haven't looked at any actual case law or broken any statutes down to see how accurate that is. But even if it does only apply to individual celebrity personas, though, I can think of several individual famous musicians that might be able to bring legitimate right of publicity claims if someone were profiting from their likeness. So I do think a right of publicity claim being brought is probably a legitimate issue and a risk that at least some tribute bands should probably consider and speak with an attorney about. I've also read that in at least some states, like California, for example, an infringing defendant can be on the hook for not only actual damages, but punitive damages and the plaintiff's attorney's fees and court costs as well. So losing a right of publicity infringement case can feasibly come with a pretty hefty price tag. Now, if there are so many potential legitimate legal claims that could hypothetically be brought against a tribute band, then why are there so many tribute bands? Is there a legal way to do it? Actually, yeah, there is a legal way to do it, I believe, through contract law, but it's certainly not guaranteed, and I think it's probably pretty difficult. Essentially, it would mean getting the band's, like the original band's, explicit permission, and I would definitely recommend doing that in writing, and having an IP lawyer draft the contract for you. But one issue with that is that the band or artist or group doesn't have to give you their permission. If there are rights that you need that don't fall under a compulsory license, there's not much that you can do if they tell you no. And some bands may be willing to give you permission, but they might require huge compensation. What makes it even more complicated is that sometimes it's not even clear who actually owns the rights and is in a position to grant you permission. The band may have assigned their rights to a holding company or a publishing company or a studio or any number of different scenarios. And it could be that the different rights that you would need to pay tribute to just one band are actually owned by several different owners, and you would need the permission from the owner of each of those individual sets of rights to go out and legally do a tribute. Or maybe the band is broken up and are in a dispute amongst themselves to figure out who even owns the rights in the first place. So it can get kind of complicated pretty quick, and each individual case is going to be extremely fact specific. At the end of the day, though, most intellectual property rights are policed by the owners of those rights, which means that usually it falls to the original band or artist to go after potential infringers of their intellectual property rights. Does that happen? Yes, absolutely that happens. And if a tribute band is operating without the express permission of the owners of the intellectual property rights, they are taking a legal risk, for sure. For better or worse, though, there are some disincentives for bands to crack down on tribute bands, and a big one is public opinion. If anybody remembers when Metallica went after Napster back in 2000, Metallica got a whole lot of very bad press from that. When news broke in 2016 that Metallica had sent a 41-page cease and desist letter to a Metallica tribute band named Sandman, which, by the way, had formed and been playing 22 years before the cease and desist letter. But when news of that broke, Metallica responded by saying that they had no idea about the cease and desist letter, said that they wouldn't be suing Sandman, and blamed the whole thing on one of their attorneys. So, assuming Metallica is telling the truth, the intellectual property claims brought up in the cease and desist letter presumably still had a lot of merit. Pursuing the issue, though, would have involved the risk of more bad press for Metallica. And, in the end, I obviously can't speak to why they chose not to pursue it, but they could still presumably pursue it in the future against Sandman or against any other tribute bands that they think are infringing on their intellectual property rights, if they haven't given those bands express written permission. Pearl Jam also got some press relatively recently for going after a London-based tribute band. They called themselves, of all things, Pearl Jam, although they did take the extra step of spelling jam with 2 M's, at least, I guess. For their part, the tribute band seemed pretty upset and, even hurt by the cease and desist letter, based on the comments that I could find. I didn't find any public comments from Pearl Jam, but I think that's a case where they are barely clearly within their rights. On a more philosophical level, I think it is important for people to think about why we have laws like this. At least one justification is that we want to make sure artists are profiting from their work. If their work is valuable enough to become commercially successful, we as a society want them to benefit from that commercial profit so that they can support themselves and thereby continue to create valuable art. When we let other people infringe on those rights and infringe on that commercial success, we run the risk of pushing the creators of valuable art away from creating more valuable art. I don't know where we draw the line. I'm just saying it's something that I think we should keep in mind and think about going forward, especially as we as consumers take in and pay for art in all of its forms. Anyway, this is Widener Law. If you would like more deep dives into legal topics like this, you can find me on here. And if you like and subscribe, it will help keep me on here. So thank you all. Peace.